So with that, I'm going to pass it right over to Anne and Barb in the talk that I affectionately call 50 Shades of Trust regardless of weapons.
Thank you. Am I good? Good. Actually, I did not even put the title to Barbara. I vetoed it before she even saw it. When my 15-year-old, I mentioned it to her, she went, "Oh, gross, you're too old for that, Mom." So thank you for having me. You're a bit of a scary-looking audience. I think there's a lot of knowledge out there. And I do, as Terry said, a lot of talks in the area of estate planning. And I usually start with a joke relative to the particular audience or topic. There's no jokes for trusts. I can't do it. And Terry, have been described as passionate about shoes, passionate about shopping, soccer. My kids, never trusts. I'm impressed. So I'm going to start with a random joke that has nothing to do with what we're talking about except estate planning. Is that okay, since I'm starting? And do interrupt Barb or I as we go along. I'm just going to ask you, I'm very hard of hearing. Don't hear out of this side, so you have to wave at me to get my attention if you have a question. Okay, so I'm looking around the room. There's nobody here this would apply to, but there was this older couple, and they were, just wanted to see if you were listening to me. They were having a bit of trouble remembering things, and it was frustrating, but they had found a physician. Any physicians in the crowd? Yeah. And they were seeing this physician about the memory issues, and things were getting better, and they were tickled. Things were improving greatly. They were getting much better results as a result of the work they were doing, and their memories were improving. And one day the couple was at their home, and the husband had a friend over, and they were sitting in the kitchen having coffee, and the wife was upstairs doing something, and the husband was telling his friend about this doctor that they'd been going to see and how they'd been having memory troubles and how things were getting better and how tickled they were. And the friend said to the husband, "Well, I've been having trouble too. Maybe I could go see the doctor. What's the doctor's name?" And the husband said, "Oh, shoot. What's the name of that flower? It's got prickly things on it and petals on the end of it." And the friend says, "Rose?" And the husband says, "Yeah. Hey, Rose, what's the name of that doctor we've been going to see?" My Alzheimer's support group loves that one. Barb and I have a million things we could tell you tonight and very little time in which to do it. So our hope is to do an overview of sorts on the many uses of trusts that we both run into. We divided ourselves kind of into dead and alive. I am talking about things, trust uses in our estate planning for the end of life when we passed away, in dealing with our assets after death. Barb will talk about what we can do now while we're all alive to plan for the use of our assets, maintenance, and looking after our families during our lifetime. The handout you've got will loosely follow. By all means, take a look through it, and we'll get to what we can. The thing to remember as we go through this is everybody's estate plan is different. So there's a little bit out of this that will apply to each of you, but each of your situations will be different and should be looked at individually. What I do all day long is estate planning, and to me that's planning lifetime as well as on your death. So we talk about powers of attorney, trusts, and estate planning for both while we're alive and on our death. Now, most of you have trusts in place already or have considered trusts and will already be familiar with some of the things we talk about. But what we'll talk about tonight is mostly why we have trusts, when we have trusts, how we can use them, where we can go a bit wrong. By way of a bit of definition to start, we all know what a will is. It's pretty easy. My kid defined it at age 6 as something that says who gets your stuff when you die. It's pretty good. And it's how you set it up and what it contains that is particular to your own situation. Each one of us has to have a will in place. Some of us will have more than one for various purposes. If we've got assets that can benefit from splitting things out amongst the two wills. As long as we're alive and able, we can do a new will, change our existing will. We plan our wills now as though we may never be able to do them again, but certainly we don't want to have to do them over and over again. I did a will 20 years ago that left everything to hubby, then kids, then grandkids, and then the charities that I liked. Had a hubby, had no kids, had no grandkids, but I did it as best as I could, anticipating that I may not be able to change it, wouldn't want to change it. Now I got kids and no grandkids, and we move on through it. I've made a couple of changes to it over the years. It's revocable as long as I'm able. It's changeable as long as I'm able. In my lifetime, I can do whatever I want with my stuff. So if I did a will that gave Barb my piano, might as well, the kids don't use it despite all the lessons, but if I did a will that gave Barb my piano and then I decide to give it to Terry tomorrow when I die, Barb just doesn't get my piano. I can do whatever I want with my stuff for as long as I'm alive, except in some of the circumstances that Barb is going to talk to you about. So a will says who gets your stuff when you die. A trust, for my purposes, says how we might deal with some of those things when we've died and how we might put them in the care of others for the benefit of somebody for various situations that we'll talk about. So a trust is really quite simply somebody holds something for someone else. With estate planning, so now we know that we all need a will and that we're planning for what happens when the inevitable does happen. There are many reasons we need trusts or need to consider trusts. My will has everything going to the two teenage girls when my husband and I are both gone. And one is 19 and the sarcastic one is 15. And we want them to have everything when we both die. And our will says that. And my will says that, much as I love you guys, much as you're actually pretty nice kids, if we died without a will tomorrow or we didn't say otherwise, you would get your money at 18. So the 19-year-old would have it now and the 15-year-old would wait a few years. I like my kid, but has anybody met a 19-year-old that could handle a chunk of money and you wouldn't be afraid that they would be influenced by somebody, blow it, do something silly? My will, when I did a speech one time, she came along, because I didn't have a babysitter and she was in a room back around the corner. And I talked about this and I said, for example, with my kids, I've got trusts in my will that say if we die before they're 30, the money is held in trust for them until they're 30. All you heard from the other room was, 30? My will has a trust that says if both my husband and I are gone, any beneficiary that's a child of mine has that money held for them and managed by the trustees that I've named, which happen to be my brothers. They're smart, they're good with money, they're of a similar age to me. I know they do what I would want, and they will manage that money for the benefit of my kids until they're 30, but in the meantime, they will pay out whatever my kids need in their discretion along with what I believe is appropriate. With income being paid to the kids or capital being paid to the kids, they invest the chunk and pay it out as they see fit. And it may be that the kid gets a bunch before 30, all of it before 30. It may be that the kid isn't so good and lots of it is held for longer. But I have created a trust because I am concerned that I don't think these kids should have the money before they're 30. If I die and they're in their 40s, great, they would get it right away. So I might use a trust and a will to postpone inheritances. There are many considerations in drafting those because I have to say, if my husband and I died tomorrow and the kids both had trusts set up for them, what if my daughter who's 19 has this trust and she dies at 25 and hasn't gotten all of the money? So a properly drafted trust will say what then happens to that money. The trust will set out some of the terms of which I would like money paid out for them, which I think would be reasonable. The trust will say what happens if my brother can't act, who else I'd want in place. Because most of us have people we would trust more than others to act as trustee, because it's a big responsibility. So in trusts, in estate planning, we postpone inheritances. I have many clients who have beneficiaries, like sons, daughters, brothers, whichever, who are adults, who are maybe not so good with money. Maybe they're gamblers, maybe they're drinkers, we can set up trusts in a will that provides for those people if you choose to, but provides the terms under which they get that money. Same considerations, what happens, how is the money paid out, who looks after it. We see a lot of trusts in estate planning these days that arise out of our complicated lives, our second marriages, our stepchildren, our situations where the families are even more blended than I think some of the scenarios I would have thought when I started this 20 years ago. There are many clients who have been married for a long time to a second spouse, and they want their second spouse to be looked after when they've died, but they also want to protect their kids when they've died. So you can set up a trust in your will that allows the second spouse to receive the benefit of that money if they survive you for as long as they're alive, but it protects the capital, whatever's left over when the second spouse dies, for your kids or whoever you want to. That's a good use of trust. I see a lot of pet trusts, believe it or not. You can provide a trust if you've got pets or money to be set aside for the pet to be looked after. You'd be amazed at how much that becomes an issue. But how do you draft these things? I have lots of people that want to give $10,000 to Barb to look after Fluffy. And what do you do if Fluffy is dead already? What do you do if Barb takes Fluffy and then gets rid of Fluffy?
Forgets about Fluffy.
Bye-bye, Fluffy. I was trying to think of a nice way to say that. It wasn't working. What do you do if Fluffy has special needs? We can create all of these. They're not that complicated, but they're things people want to think about. One of the big estate planning tools where we see trusts are through life insurance, and Terry has, I'm sure, talked to many of you about these sorts of issues. In my house, we have assets, and then we have that are in our names that would go to our kids if we both die. Excuse me. I have life insurance, and I can set up what is really called a life insurance trust that keeps that money separate from other monies and benefits who I want to, and maybe save some costs of probate fees and other types of things that hopefully we'll get a chance to talk about. As an option, we can set up separate trusts that take effect when you've died to deal with separate interests like life insurance. There are many people who have interesting or different assets that they want to treat in a particular way. Barb, we've left to talk more about the dreaded family cottage in the living trust situation, but we have many requests to deal with making sure the kids can still have access to the family cottage, making sure that the family house is held until the kids are old enough to buy it, live in it, afford it. There are young kids who are beneficiaries, but the parents want the people who are looking after them to be able to hold on to the family home so that the kids can stay in the family home until they're what age? How do you define that? All of these things can be set up, but they're all challenges to combine the income tax and management and other issues as to how it's all going to fit in and when the trust ends and when the properties are sold. So these are some of the uses that we have to help you, or that we can help you with rather, and that are becoming more common, certainly, in dealing with estate planning. Barb hopefully will talk to you about family businesses as well. We have to, when someone does a will, if there's a family business, consider how that's dealt with in the event that the person dies while still owning the business. And is that business incorporated? Is it a sole proprietorship? Sometimes trusts can be used effectively to allow the business to run for a period of time after the owner dies, to name who's going to manage that business and to provide for its gradual liquidation. Or a family business. We have a lot of farms that we deal with where the kids are younger and starting to learn the farm business. With farm prices the way they are right now, the family doesn't want those sold, but the kids aren't ready to take it over yet. So we have done trusts where we set up a system for management of the farm, how that's going to be determined, and then how it's going to be determined when and how that farm is transferred to the kids, or the one of the kids that looks after the farming or that has an interest in it. Where it can become a challenge for many of these assets, be it the family cottage, be it the farm, is if there's one child you want to have the benefit of that particular asset and it's worth more than half of the estate, for example, if there are 2 kids, and how you balance that sort of thing out. So we've set up trusts, for example, that allow the family business to be maintained for a period of time, and the kid that's going to take it over has to buy out the sibling, but over time. So you can provide for a way to make sure the business stays in place, the kids are looked after, and those young kids, which to me is 30 and under, don't get money too soon. There are a lot of uses for trust, but there's a lot of pitfalls as well. Some of the dangers in creating trusts. To me, when I do an estate plan, I draw out a map. So in my will, for example, it had hubby and me, and then it had the 2 kids, and I gave myself pretend grandkids, and then I gave myself nieces and nephews and charities all in a line. So the estate plan has to say in that will, what happens if this person dies before me, what happens if this person dies before 30 when they get their money. We have to plan all of that out because we can no longer change it, we've died, and you have to make sure that it follows the path that you want, and you're guessing ahead to whether people have children, whether they're mature enough. It's important to make sure that every option, every alternative is considered in drafting the trust. It's not hard, it's just you've got to plan through it. There are various rules about investing money and how long you can do that for from a tax perspective. I'm not going to explain it. I've seen at least 5 accountants in the room. But basically we can only add if my kid's money is being invested and paid out to her or for her until she's 30, and not all of it is paid to her, then the trust should provide that whatever she doesn't get gets added to the trust and her amount grows. Well, you can only do that for a certain amount of time. We have a case called Saunders and Baudier. It was decided by judges about 3 million years ago that we all heard about. And it was a case of 2 families where the family did a trust up and wanted money held for kids or grandkids, whoever it was, until, say, 30. And the trust said, I give my kid, Barb and Terry, half of my estate, and when they're 30, they can have it. And the court decided, unless there's certain words, for example, a trust that says Terry, who's only 21, if she dies before 30, who would take what she was going to get? Then that's void. So I had an estate, because there's nobody to give the money to, it means it's absolutely Terry's, as long as she's an adult. I had 2 18-year-olds years ago who inherited money from grandma, and she had a trust set up that it was a huge amount of money, call it $1 million, and to an 18-year-old that's unfathomable. And she had a trust that said it was going to be looked after by Barb until she was 30. And it said to hold the money in trust and pay the income to the kids until they're 30, and then you can give them the chunk. It didn't say what happens if the kids didn't get to 30. Now, I've changed enough facts that if you knew the people, you wouldn't recognize them. And I had to act for the kids, so I had to say to the executors, you have to give these kids $1 million now. And I was right. The will wasn't drafted, that wasn't done properly, and I got those 2 kids $1 million 12 years sooner than Grandma wanted them to have it. One of them blew it within a couple of years, the other is doing quite fine. So there's drafting issues, putting the puzzle together, making sure all the pieces provide for all the possible scenarios. When you set up trusts, and you can do so for income splitting, so for example, you can, if you have a trust, and their spousal trusts are discussed a lot, so it's husband in this case, instead of giving his assets outright to his wife, puts them in trust for his wife in his estate, and that trust carries on, and there's terms about how she can use it during her lifetime. There's rules about making sure it's kept so it's not tainted, in terminology for income tax matters. And so she would have her own income that's taxed at graduated rates, and trusts in wills that earn income, they're taxed at graduated rates, just like people. So if you have some money you give to your spouse and some money you directly and some you hold in trust, and then you've died, your spouse may have 2 graduated rates of income effectively, and trusts are used that way. I had one of the lawyers at our firm come down to my office at about 5 o'clock, and he said, "Really, how often are these used?" Not that often. They have to be right for the circumstances, and sometimes they're perfectly right for the circumstances. When you go see the lawyer, when you put it all together, these are all the sorts of questions that you need to ask to see if they're right for you. A couple of things I want to make sure I get to so I can give Barb a chance to talk. One of the biggest and best, in my view, uses of trusts, and one that is growing in terms of the numbers of times that I see it. Adult beneficiaries, be it your child, your sibling, who is in receipt of disability benefits here in Ontario. I've worked with BC stuff and some of the other provinces, so we're really only talking Ontario right now. If you are over 18 and you meet the definition for the Ontario Disability Support Program benefits, you can be in receipt of a monthly income. And if you are in receipt of that monthly income, you can have a bit extra, but whatever you get above what you're allowed is a direct clawback on your income. And you can have a certain amount in the bank before it's a clawback on your income. The money you get isn't a lot, but for many people, the main benefit of ODSP or disability income isn't the income, it's the drug benefits. If you qualify for ODSP, your drugs are covered, and that's often equal or more than the amount of the income that you receive. Disability can be mental, physical, combination. Each situation is different. If I have a child who is in receipt of ODSP, I want to make sure that child's looked after, but I'm hoping I can continue that child on his or her benefits. For many, many years in this province, there were various ways tried to set up people's estates so they could look after these kids but still keep them on these long-term benefits. Because if I died and I gave my kid Barbara, who is on ODSP, a couple of $100,000, she would have to go off her ODSP until she spent all of that $200,000 and then apply to go on, because that's above the limits of what she's allowed to do. Me as a parent, I've tried many ways to get around that. So there have been a lot of plans tested at the courts as to what would work. And ultimately, the courts approved something that we call affectionately a Henson Trust. And Henson is nothing more than the name of the family that ended up at the Ontario Court of Appeal. One of the names of one of the families that ended up on the Ontario Court of Appeal that came up with something that was approved and later legislated. We can provide for our beneficiaries, in this case a child who is an adult in receipt of benefits or who may be in receipt of benefits, if we set the money, so if Barb is my kid and she's the one, and I've got $200,000 to give her, instead of giving it to her outright, my will says that my friend Terry will hold that money in trust for Barb, and that she's to use that money with Barb's best interests in mind, but that she can also pay that money out to other beneficiaries, and whatever she doesn't pay to Barb gets reinvested. And at the end of the day, it'll say, it has other terminology to it, and at the end of the day, it'll say, use that money for Barb's funeral, and then what happens to the rest of it when Barb's died 40 years from now, maybe to charities, my grandchildren, whatever. If the wording is done properly in a Henson Trust, then Barb's benefits and her inheritance can go side by side, and Terry, as her executor, has permitted expenses she can make on behalf of Barb. You can buy houses, you can buy cars within the limits of the legislation. If I gave it to Barb outright, Barb has to go off benefits until she spends it. There are some exceptions to that rule, but they're very limited, and the amount of $100,000 If Barb is capable, can set up her own trust, but anything above 100 she'd have to spend. The Henson trusts, for example, are very flexible, so if Barb's disability goes away or she's able to work or she has greater needs, Terry can pay her out more. This is a trust that works well that we see often. I want to just very briefly comment on what I call accidental trusts. Now, I wish we could talk about probate fees for 4 hours, and I'm afraid to say the word or I will get asked about probate fees for 4 hours. However, there are many things people do to minimize costs on death. Some are good, some are intended, and some are effective, more effective than others. One of the ways we hand money to others on our death is by having it jointly. So if Barb and I had a joint bank account of $100,000 and I died, she is the survivor, it's hers. The law will say in some circumstances, and we can only talk generally today, that Barb isn't really the beneficiary of that money, that she holds it in trust for my estate, that we did that to make it easy to get to her to save some fees on death, but really she doesn't have the beneficial ownership or the right to use the money. She is holding it in trust for my estate for whatever my estate has. So I call that the accidental trust. The courts have said my intention is relevant. So when I create that money in trust, I should be writing down a piece of paper, I intend Barb to have that when I die, in which case it will be all Barb's. This is a big tool these days. I think we lawyers have to ask people as part of our estate planning, what do you have joint with people? What do you have that names beneficiaries? And write down what the intent is, because by giving that money in joint ownership to Barb, depending upon what the law decides, it may not be what I intended. So I may have created a trust accidentally. So there's lots we could talk about. I feel like I've just jabbed around at various topics, hopefully piqued your interest on a few things. Estate planning is relevant to what you've got. You should sit and look at everything and how it fits together. It has to take into consideration various assets, who your beneficiaries are, who you want to look after. You're guessing the future a little bit, but it's all part of a package that's unique to you. Part of the estate planning is what we do before we get to the will, and Barb, I think that's you. Now, I think I have to give us a minute to take these things off.
So I'll be talking about inter vivos trust during your lifetime that you can set up. We often hear them referred to as family trusts. When the beneficiaries are family members, they're called family trusts. And they can be very effective planning tools as well in specific circumstances. In other circumstances, they are not as beneficial. Anne spoke about the fact that testamentary trusts are essentially their own person in that they're taxed at the graduated tax rates as a separate person, and that the inter vivos trusts are also considered their own person, but they are taxed at the highest tax rate unless that money is flowed out to a beneficiary who is a lower tax rate individual. So in planning for inter vivos trusts, it's very important to remember that unless there is someone each year to receive income that is a low tax rate individual, that trust will be paying tax at the highest tax rate. And that the individuals who might be lower income individuals and able to receive the money also need to be 18 because of the kiddie tax that's in effect if there's an attempt to flow money out to minors. I'm going to talk, really I'll divide this up into two categories. There's the use of trusts for normal businesses, individuals who often have family businesses, and then there's the individuals who are professionals, have professional corporations, and how trusts can fit in with your life as a professional, because they are quite different. Purposes of these trusts are obviously income splitting is important. For family businesses, we're often attempting to split the wealth of the family business by having the younger generation share in the growth of the value of a company, and also deal with succession planning in a family business between the generations. So I will talk first about the purpose of the family trust in a family business context that is not a professional corporation, and where that works well. I deal with a lot of corporate reorganizations, farms, as Anne mentioned, other types of family businesses, where often the children are coming into the business. The parents feel that they've grown the business to a level that they are going to have enough money in their lifetime, or are likely to have enough money in their lifetime, given the value of that business at that date, that they would be happy to let future growth be in the hands of their children, but perhaps not directly. So for example, if mom and dad have grown a business, it's now valued by the accountants at $2 million. We are called in and we can do what's called we call it an estate freeze, or just a freeze, and freeze that value for the parents, that their shares that are always just worth the sum that the company is worth are frozen into special shares, which will have a fixed value for the rest of time. And that then leaves open for the children to come in and buy those common shares that are now worth zero, because all of the value is frozen in these special shares, and any future growth of that business would then accumulate to the children. That's where a trust comes in as a good alternative to the children directly being able to buy those shares. We often use a family trust to buy those shares, largely so that the parents can still maintain control, and secondly, so that there can be flexibility in who is actually going to benefit from that future growth. Trusts these days are much more flexible than they used to be. If I'm creating a family trust in this family business scenario, I don't need to say each of my children are going to be the beneficiary. If I had 2 children, I only have 1, but if I had 2 children, each child will be a 50% beneficiary. I can name the beneficiaries as any of my children, any of my grandchildren, myself, any niece or nephew, and then at a later date, I can decide who I want to benefit. I don't need to decide that now if I make that category of beneficiary quite broad. And I can also ensure that that I am the trustee of the trust, and other people who I know will make or I'm confident will make decisions that I want them to make, so that my children are not directly in control of that family business, that I still maintain control. And as kids are coming into family businesses, it sometimes works out, it sometimes doesn't. So I never like to see parents giving up control to children if there's a way that we can avoid that and keep things more flexible. So that's the family business scenario. The professional corporation scenario is quite different. First of all, trusts are not permitted to own shares of a professional corporation. And I think many of you are dentists, doctors, and have professional corporations. Am I right? So trusts are prohibited from owning shares in a professional corporation. And that is one reason that the trust scenario is different with professionals. Another reason is that professional corporations have some very unique and beneficial income splitting strategies already that you can use. Canada Revenue Agency has been very generous and very tolerant with professionals in allowing family member shareholders to own shares of professional corporations that really have no intrinsic value or very nominal intrinsic value, with the ability to receive very large dividends. So I'm sure most of your professional corporations are set up the same way, that children, maybe parents, maybe your spouse, own these special shares that might be worth $1, $10, $100, that really are not, have no real value, but you're dividending your 18-year-old child $30,000 a year on those nominal value shares to go and pay for university. I'm no accountant, but I hear consistently from accountants that that setup is not as tolerated by Canada Revenue Agency in regular corporations. So that the professional corporations have an advantage in being able to income split with spouses, but also with their the other generations in their immediate family, that is not as easily done in a regular corporation. The other difference with the professional corporations is that succession planning is rarely an issue. That if your child, it's rare that your child is going to come in and take over the dental practice, or the medical practice it doesn't have intrinsic value. So so you're rarely going to have succession planning concerns. The one area where I do see trusts, and we have set up trusts for professionals, is with dentists who have very large practices and decide to split that practice into two different corporations: the hygiene corporation or technical services corporation, and the dentistry professional corporation. And that the purpose of that is largely to get two small business deductions, have two companies that each have the small business deduction and can overall result in lower tax. In that case, often the spouse, maybe children, are going to own shares in the hygiene corporation, where the dentist is going to continue to own shares in the dentistry professional corporation. We are now more often using a trust to own the shares in the hygiene corporation, with again with the broad range of beneficiaries, but that the dentist is one of the trustees and ensures that the dentist maintains control over that hygiene corporation, as well as the dentistry professional corporation, with the benefit of two small business deductions. That's also very good planning from a family law perspective as well, because you don't want, as a dentist, you don't want your spouse to own your hygiene corporation if you're not getting along too well. The last thing I'll say about the professional corporation scenario is because my opinion really is, unless you're in the very large practice category where you do need two small business deductions, that it is unlikely that it's going to be beneficial to you to use an inter vivos trust as part of your business planning. If you have young children who you want to save money for their benefit once they turn 18, you're able to do so in your professional corporation at a very attractive tax rate, at the small business rate, 15.5%, right? So that, and if you were to put $100,000 into an inter vivos trust, and there was no beneficiary who was yet age 18, that money, any income earned on that money, would be taxed at the highest tax rate. So your 15.5% rate on any investment income that's being earned and that you're saving for your kids is well placed in your professional corporation. The cottage trusts. I will now move on to cottage trusts. And I won't, we were talking earlier that this is a hot topic, and people have very different opinions on it. Cottage trusts can be created either in the will, or they can be created either when you're buying the cottage. You can create a trust for the sole purpose of purchasing the cottage. If you already own a cottage, you could create a trust and roll the cottage into the trust. That is only, or normally only, a good idea if the cottage has not increased much in value, because that is a taxable transaction. There's also land transfer tax if you're rolling a cottage that you already own into a trust. So certainly the best time, if you're going to put a cottage into a trust, the best time to do it is when you purchase the cottage, or to take care of it in your will. It's important that that you then, if you set up this trust, there needs to be provision for how repairs are going to be paid, for operating costs, and many provisions for how your family members are going to share the cottage. And my experience, I'm not sure if Anne would agree with me, is it usually does not work. It's not, you can create a fabulous trust, and it can be well drafted, and people just don't get along, and it becomes a bone of contention for your family members, that they probably would have just been better off if the cottage was sold, or if kids got to draw lots as to who would buy the cottage.
Light a match. Stop it.
And sometimes the siblings, they can get along, but it's their spouses, right?
Plus also, often the financial abilities of the various kids is not equal. And that can create real problems in what the plans are for the cottage. When the community comes along and says you have to put in the sewer system, even for expenses, it can be so. Then you can set aside an amount of money to look after the cottage, and that becomes its own set of issues.
And then the kids who don't use it very often say, oh, all the money's tied up in this cottage, and I'm only there 1 week a year, and yes. So although cottage trusts are doable, it's something that requires a lot of consideration and caution before you go down that path, in our opinion.
And thank you so much for making a very complicated subject very simple. And that's the value of people like Barb and Anne, because trusts are very, very difficult to understand. I know that in the world of financial planning, so many things are very hard to understand, and there are massive books that are written about financial planning. And I say to people, forget the books, there's only 3 things you need to know. Limit your spouses, limit your kids, and limit sports and music lessons, and beyond all, don't get into horses. So that's the end of the financial planning. With regards to trust, though, I'm a firm believer in trust. And I think that any business owner or anybody that has a person with a disability or anyone that has a lot of assets should always think about the trust, because the trusts allow you to create your own world. And I remember when I was growing up, I used to say to somebody that was trying to tell me what to do, you're not the boss of me. When you have a trust, you are the boss. You can absolutely do anything you want. And if we look at it a different way, if I was to say to you, do you know that you have the ability to create an environment of which you can avoid probate tax? You can plan on who pays the taxes, whether the trust pays the taxes or whether the individual pays the tax. You can put your own wishes in as to how that money is paid out. You can plan your wishes as to who gets the capital, who gets the income. You can actually plan as to where it fits into family law. There is nothing that can't happen in the world of trusts. And it doesn't matter whether you're dealing with a trust that you create while you're alive, called inter vivos, or a trust when you're dead, which is called testamentary. And so for those of you that have businesses, the ability to pass shares and assets out through a testamentary trust is unbelievable. And people like Barb and Anne allow it to do it. I was recently part of an interesting case where the deceased passed out $50 in testamentary trust to a lot of the beneficiaries who were family members of a large business owner who immediately did a freeze on their existing corporation and issued all new growth shares into the testamentary trust on behalf of the family members. Not a bad deal. Why is that important? Probably a lot of people are looking at me going, what, Terry, what are you talking about? Well, let me just tell you the outcome, and that's all you need to know. In a testamentary trust, which is taxed as its own person, you can earn in dividends about $40,000, $30,000 to $40,000 without paying a dime of tax. Now, could you imagine if you had 3, 4 testamentary trusts, each owning common shares, and each one of those 3 or 4 testamentary trusts passing out $30,000 to $40,000 in tax-free dividends every year? Would that be of value to you? And the point is, of course it is. And that's the kind of thing that can be done with proper planning. Does it take time? Yes. Does it take education? Absolutely. And does it need to be done with professionals like Barb and Anne? Absolutely. And Barb and Anne don't act alone. There are the accountants involved that are critical to making sure that this all works together. And so that's why I'm so pleased to have Peter, John, Lane, Brandon in the room, because these are the ones that all work with you and decide how that is going to happen, whether your child is disabled, whether you're concerned about matrimonial issues, or so on. These are the people that can help you move forward. So with testamentary trust and inter vivos trust, never underestimate what a trust can do, because they are very important. The only other thing I can say with regards to estate, which I think is very important because we deal with a lot of estates, let your spouse know what your password is to the password protector on your iPhone. Because all of us have at least 100 passwords. And I don't know who is going to figure that out. But it's probably a really good idea that somebody knows the password to the password protector on your iPhone. This is a new phenomenon. It might be a good idea that people know where your money is and where your will